Good morning, good afternoon, good evening. Thank you all for joining us. My name is Jacob Phelps. I'm faculty at the Lancaster Environment Center and one of the co-executive directors of Conservation-Litigation. Thank you very much for joining us. We really feel that the breadth and diversity of interest in today's discussion really reflects something we were discussing just before the discussion with the participants. It really, we feel it reflects a broad demand for access to justice in the interest in the environment. And it's no wonder. Harm to the environment is ubiquitous and unprecedented in its scale, whether it's from mining or illegal wildlife trade or deforestation or pollution. And so today, what we're going to be focusing on is what comes next. How do we use legal action when the environment's harmed? And what are nature's rights when the environment has been harmed? This is, of course, important because environmental harm, our responses can involve punishment, fines, imprisonment, and those are an important function of criminal justice responses to illegal action. But from an environmentalist perspective, like myself, of course, they're inadequate. We also need to deal with the scale and the legacies of environmental harm. Who is going to restore injured environments, clean up pollution, deal with injured animals, help a species population to recover, compensate affected communities or state agencies, address harm to human well-being in all of its dimensions? We know that legal regimes already exist that help us to address many of these things, whether it's environmental liability provisions that order offenders to clean up, restore, remedy the harm that they have caused. Importantly, an entire series of new and emerging legislation, which we often know around the phrase of rights of nature, that grant nature the types of rights, the types of legal protections that you and I and indeed corporations already enjoy. But as we're going to discuss today, having those rights on paper and operationalizing them in practice is, right, there's a big gap between there. And there are a number of scientific, legal, practical challenges to operationalizing these rights when nature's harmed. And today's speakers represent some of the leading scholars and practitioners who have been thinking and working through these issues so that when nature's harmed, we can secure remedies. And so it's a pleasure to call upon them to help us understand and think through a little bit about what happens when nature's harmed. Our format today is going to be, hopefully, a relatively fast-paced series of questions for our speakers. Just a few small housekeeping issues. Please kindly keep your cameras off and your microphones muted. Please see in the chat if you would like to sign up either for more information or indeed to receive a recording or for any of the answers to follow-up questions. And on the point of questions, please feel free to share your questions in the chat. At the end, we'll have some time to address those. And for the ones that we don't address, we'll be following up with an email for you with further information. And as I mentioned, we'll also be sharing a recording of the discussion. So today's discussion is organized by Conservation-Litigation.org, which is a group that I am involved with that helps to think about how we operationalize existing liability provisions to support our conservation and environmental aims. And we're really pleased to be joined by our colleagues at the IUCN Task Force on Rights of Nature, as well as the IUCN World Commission on Environmental Law, Biodiversity Law Specialist Group. And perhaps even more so by our speakers. Today we have Philippe, who leads the IUCN Task Force on Rights of Nature and has been immersed in these issues for a number of years. Yaffa, whose work has been comparing rights of nature across jurisdictions, looking at the emergence of this concept and its practice and its implementation and the challenges that have gone along with that. My immediate colleague, Maribel Rodriquez, who's been working on thinking about rights of nature and nature's rights more broadly, and thinking about how when nature is harmed, what are the diverse legal tools that we can draw on in response to that harm? And I think really importantly, we have two leading environmental litigators who are worried with the technicalities of using these laws in practice in their contexts. Blair from Uganda, where rights of nature as a legal concept already exist, and whose wife is currently in labor. And so we particularly thank you for joining us. And also where, of course, a number of legal strategies can be used to address that. So Blair, please feel free to drop out if and as you need. Thank you so much for joining us. And of course, a longtime friend and colleague, Gerthie in the Philippines, where rights of nature legislation per se does not exist, but where there are a number of existing pieces of legislation that can help us perhaps exercise rights of nature. So let me please briefly ask you to each introduce yourself, and then we're going to jump in. So Yaffa, please.
Hey there, thanks everyone for being here. I am an associate professor of environmental law at Uppsala University in Sweden, and I've been working, focusing on biodiversity issues, and in particular, rights of nature for about, for a long time, rights of nature specifically for about 5 years.
Thanks, Yaffa. Hello, Gerthie.
Hello, thank you, Jacob. Good afternoon from the Philippines to all our colleagues. I'm Gerthie Mayo-Anda from the Environmental Legal Assistance Center, a public interest law group here in the Philippines. I'm based in Palawan, the country's last ecological frontier. I'm also teaching environmental law in the Palawan State University College of Law. Mabuhay.
Thank you, Gerthie. Hello, Philippe.
Hello, everyone. I'm professor of environmental law at SOAS in London, and I've been working on environmental rights discourses for a long time and progressively shifted to rights of nature as well. Thank you.
Blair, hello.
Hello, everyone. My name is Blair Atwebembeire from Uganda. I have worked with the Uganda Wildlife Authority for quite some time. I worked with them for about 7 years before I left and joined practice. I'm now managing partner. We continue to advocate for environmental rights. I also work as the legal advisor at the Space for Giants, which is in Nairobi and also headquartered in the UK. You will forgive me if I keep breaking. It's because of connectivity, but I hope that I can communicate something today. Thank you very much.
Thank you, Blair. And finally, Maribel.
Hello, good morning from Brussels. Hi, good evening, good afternoon, Philippe, Yaffa, Gerthie, Blair. It's a real pleasure to be sharing this time with you today and learning from you. My name is Maribel Rodriquez. As Jacob mentioned, I am co-founder of and legal director at Conservation-Litigation.org and at Law and Wildlife. I've been studying environmental laws for over 20 years now, with a focus on understanding how conservation laws work across countries. And nowadays, I divide my time in two big projects. One of them is bringing conservation laws closer to conservationists by analyzing those laws and translating them into a simpler and more practical language. And the second big project that brings me here today is exploring how to make those who harm nature liable for the harm they cause. So thank you again. I'm really looking forward to getting into the topic.
Great, thank you. And let's jump right in. I just want to start very briefly with you, Philippe. If you can help us, we want to understand some of the basic terms so we all start kind of on a similar point, some of the legal concepts that we need to understand. So you've been leading the IUCN Task Force on Rights of Nature, so I can think of no one perhaps more appropriate to help us get started. What are the rights of nature? And when nature is harmed, what do these rights of nature mean for the rest of us?
Okay, so I'm sure, as you said, there is a short and there is a long answer. So for now, we'll stick to the short, and one of the short answers. So right of nature is one way to conceptualize environmental protection through a lens that prioritizes nature. And I guess one of the ways to oppose that to something else is to oppose it to the integration model of sustainable development, which is what we've lived through in terms of leading policy concept for the past few decades. So that in a way is the ecocentric part of rights of nature. Second element is this is framed in terms of rights. There are good reasons why that's the case, because it provides a link with the rights discourse, which is still seen as having potential for focusing on the situation of the most marginalized individuals, communities, peoples, and so on. And the rights discourse also has the legitimacy that human rights gives it. But then what's immediately very important is that this very definition through rights means that we're in a context which is not purely ecocentric. And that I'm sure will come back in throughout the discussions we have. Now, in terms of the second question as to what happens, what does this mean when nature is harmed? I guess this is the point at which it becomes immediately clear that it can't be only ecocentric. And that, I guess, is something which is becoming increasingly visible to everyone involved in the debate. Now, when nature is harmed, there is a duty to repair, which is for the time being a human duty that might change in the future, but for the time being, that is where we are. And then the question is, who is included in this? Is it a state duty? Is it something which is mediated by an independent institution? I guess we'll come back to this in later questions. Is this a duty of individuals, communities, or legal entities that have caused the harm? These are the questions, in a way, at the center of the problems that framing things in terms of rights of nature brings to us. Okay,
Great, thank you. That's great. Thank you, Philippe. And I think that eco-centric versus anthropocentric and human rights approach are really hard to disentangle. Yaffa, you've been comparing rights of nature legislation across countries, both some of the longer standing ones as well as the emergent ones. Can you give us some examples of what this means in real life?
Yeah, yeah. So each rights of nature law is, of course, a little different because laws are adopted at the national level, although there's been a lot of trends impacted by international sort of organizations and movements for rights of nature. But I just want to highlight two that are on very different scales. The first of these is a very well-known Ecuador Constitution, which establishes that nature, or Pachamama, where life is reproduced and occurs, has a right to integral respect for its existence and for the maintenance and regeneration of its lifestyles, structures, functions, and evolutionary processes. It also has a right to be restored. So that is that nature as a whole has substantive rights, including essentially the right to be repaired or made whole if harmed. And this is entrenched in the highest law of the state. Many rights of nature laws have also been adopted at the community level or at the city level, municipal levels, county levels. So for instance, in the United States, the city of Santa Monica has adopted a sustainability rights ordinance, which says that natural communities and ecosystems possess fundamental and inalienable rights to exist and flourish in the city of Santa Monica. The law goes on to say that any city resident can bring litigation to protect these ecosystems and natural communities, which it further defines as groundwater, atmospheric systems, marine waters, and native species within the boundaries of the city. And Santa Monica has passed additional ordinances that give effect to this ecosystem rights ordinance, such as limitations on the use of groundwater. So we see it having an effect, although I'm not aware of any litigation being brought yet under this law.
That's fascinating. And I know, of course, Maribel, that your work is focused on that litigation specifically. Can you help us to understand some thoughts about how rights of nature can take body in those contexts when, we're not trying to stop nature from being harmed, but it already has been harmed? What do nature's rights mean for us then?
Thanks, Jacob. So my reply is going to be in the line of Philippe's and Yaffa's. In our experience, what we are seeing is that the rights of nature encompass many different legal pathways. But the underlying principle across these pathways is the same. which is that law must acknowledge that our relationship with nature is not purely an economic one. Humans and nature, we're interlinked, we're part of an interconnected world. So rights of nature is nothing more or nothing less than the need for the law to establish rights and obligations that reflect this interconnectivity in an appropriate manner. So from the rights of nature perspective, what we can see is we can look to the future by establishing this legal personhood of species, habitats, rivers, forests. We can look into the present by enforcing the rights that exist, including the right to a healthy environment that is enshrined in many different laws around the world. And importantly, and overlooked, is this look to the past. What do we do when nature is harmed? We know that many countries recognize that when nature is harmed, there is a need to repair it. And this is an important tool because it will help us reverse biodiversity loss, but also because it's already there and hardly ever used. So I believe this is the beauty of the rights of nature, right? That we have many different solutions, but they are all interlinked with this underlying principle that humans and nature are one.
I mean, I think this is one of the things that excites me about rights of nature is that it is expansive. It certainly reflects my value set and starts to bring that into legal fora. But I have to admit, it still feels quite abstract for me. And Maribel, I'm hoping you can talk a little bit more about, right? I'm not a lawyer. What are the types of legal actions that this opens up when nature is harmed? What can we actually do?
So what we can do, there are many different, well, no, I wouldn't say many different. There are a few different legal tools. One that is heavily relied upon is the criminalization of specific acts that harm nature. So imprisonment sentences, financial penalties to punish and deter. We also have injunctions to stop a specific harm or to prevent harm that is likely to happen. There are possibly also orders for authorities, basically to do their job for protecting nature, and these orders to remedy when nature has been harmed. Now, since I'm more familiar with them, allow me to elaborate a little bit more. So in our research, we have discovered that there are three important elements that we have identified across countries. The first and most important one is to determine appropriate remedies. We need to determine what is the scope of the harm. Now, we tend to think that harm equals economic loss, but really it's not like that. When nature is harmed, there might be harm to individuals, harm to species, harm to ecosystems, habitats, harm to those ecosystem services that nature provides. But not only, there's also harm to society, harm to cultural, religious, or emotional values, and even there's also harm to the survival of our future generations. Now, if you allow me, I'll give some examples. There are some countries that acknowledge this broad range of harms by recognizing the intrinsic value of nature. Costa Rica, I think Yaffa mentioned Ecuador, India, Canada, New Zealand, they all acknowledge this intrinsic value. The second element that I'd like to highlight is that the person responsible for the harm must repair it, either restoring it when, for instance, deforestation has destroyed a forest, or pay the cost for care, rehabilitation, or introduction into the wild of species, but also, most importantly, together in combination, pay a compensation for that harm. This is reflected in laws in Mexico, Brazil, Liberia, and Angola. And the last point I want to make is that remedies can and must be used to repair intangible harms, such as harm to cultural values. In China, for instance, courts systematically order offenders to issue public apologies when this has been happened. So to sum up, I think the law is not really short of tools. The key is to understand those tools and use them strategically to uphold the rights of nature.
Great, thank you very much, Maribel. I'd like to turn to Blair, if possible. Blair, are you still there?
Yes, I am here.
Great, thank you. So, as I understand it, Uganda's constitution already recognizes the right to harm, right? And there are also other legal provisions that that grant remedies and help to secure nature's rights when it is harmed. If I'm not mistaken, those rights of nature have not necessarily been enforced, i.e. the law is there, the provisions are there, but they haven't necessarily been used. But I understand that there is at least one local government regulation that has elaborated on this, that explains how they should be operationalized. It gives us some indication of direction. And I was hoping you could speak a little bit about this opportunity, because again, I'm curious for what does this mean on the ground when something actually happens, when nature's actually harmed? How are we seeing that in Uganda?
Well, thank you very much, Jacob. It is true indeed that the Constitution of the Republic of Uganda, in a way, recognizes nature rights, particularly when you look at the provisions that talk about the right to a clean and healthy environment. When you look at how the Constitution gives the power to every Ugandan or every organization who think that that nature has been affected, giving them a right to either bring a claim in courts of law or at least raise complaints with the relevant organizations that regulate environmental matters. So yes, the law is expansive. There are many ways through which you can enforce nature rights. Yes, there have been a number of cases that have come to court and actually enforced these rights. But recently, the point that you're talking about, there has been an attempt to, enforce nature rights through what we call cultural laws or cultural customs. Traditionally, nature in our community in Uganda had been really conserved, preserved through our customary rights, through our customary, beliefs and practices. And so when these customs fade away, it means that people start abusing nature. They start enforcing on spaces that were traditionally supposed to be maybe saved for cultural rights. And this is what currently one local government is looking at. They have passed an ordinance that recognizes customary laws in respect to conservation of particular spaces that are so fragile, ecosystems that are fragile, that traditionally have been used for customary rights, and we are being conserved in that line. And particularly, this is the indigenous Bagungu communities who live in the Bulisa district in Western Uganda, who believe that if you conserve culture, if you conserve these cultural rights that we are traditionally conserving and preserving our environment, then initially, by extension, you're going to be conserving these sensitive ecosystems that are very, very important to nature. So in a way, by recognizing these customary rights, by recognizing these customary laws, we are in effect recognizing nature rights that are being protected under these different laws.
Thank you, Blair. I mean, that's what we're hearing actually across the speakers already, is that these are quite expansive. And I'm curious, Yaffa, how do you understand the scope of these rights when nature's harmed? Like in the countries that you've been looking at, how broad are these rights, and how are they manifest, how they're understood?
Thanks. So there's, I guess, two broad trends in rights of nature laws when it comes to the protected entity. Some laws, like in Ecuador and Bolivia, protect nature as a whole, and others protect specific entities, specific rivers, specific ecosystems, or specific types of entities. For instance, in that Santa Monica law, where all rivers or all ecosystems or natural communities and within that jurisdiction are protected. So when they protect specific entities, for instance, like the Mar Menor Lagoon in Murcia, Spain, it can be fairly clear who the protected entity is. In that law, the legal person is defined as a particular biogeographical unit in a particular geographical location, particular named aquifers. There can still be uncertainties at the margins of who is this Mar Menor, but essentially the Mar Menor rights-bearing entity is the area defined in law. The situation is different in Ecuador, for instance, where nature as a whole is a person. And it was at first pretty unclear what, if anything, this would mean, but as the Constitutional Court has sort of developed, rights of nature can be applied to entities on different scales. For instance, in one case, they said all mangroves have nature's rights. In the precedent-setting Los Cedros forest case of 2021, that case concerned mining or exploration in a biodiversity-rich cloud forest. And there, the court held that these mining activities would violate the rights of nature because they could harm that specific ecosystem, which it defined geographically in the court case, and also that it could harm the species within that forest could have rights that would be harmed. Interestingly, individual animals can also have nature's rights or can also be protected by nature's rights. In the 2022 Estrellita case concerning an individual woolly monkey, the court noted that the animal is a basic level of ecological organization, and as an element of nature, it's protected by the rights of nature and enjoys an inherent individual value. So we see these as courts are developing rights of nature in these countries that have broad rights of nature, that they're often applying it, to the entities that are before the court, essentially, in a way creating new rights-bearing entities.
So sometimes very targeted and specific, other times super expansive, and we're wading our way through, I guess, defining those through the courts. I'm curious about Gerthie in the Philippines. Now, if I'm not mistaken, the Philippines does not have rights of nature legislation per se, like the ones that Yaffa was describing. But nature still has rights when it's harmed already, right? What are the bounds of those in the Philippines?
We are fortunate. We have the Wildlife Act, the laws on protected areas. So if a community, indigenous people's community, would represent a protected area or a pangolin habitat, for instance, which has been destroyed, then they can seek actually restoration and rehabilitation. So in that sense, nature has to be restored and rehabilitated. Of course, there can be compensation. So we are, despite the absence of a specific law, we do have our own natural resources environmental laws, which provide for remedies. So you compensate, you actually defray the cost of rehabilitation if there's an oil spill that would destroy hectares of mangroves or hectares of coral reefs, or if mining, example, would destroy a protected area. Our laws provide that these areas are supposed to be protected, and you cannot actually pursue extractive activities in protected areas. Of course, having said that, Jacob, laws are only as good as their implementation. So the challenge actually in the Philippines is making sure that these laws are well enforced. And to do that, you really need a lot of resources, warm bodies, and political will altogether.
Thank you, Gerthie. And Philippe, this is a question I'm still trying to get my head around, which is there are obviously, like in the Philippines, lots of legal rights that already exist that represent maybe not rights of nature in a specific framing, like this river has certain rights, and we name it as an individual with rights. And yet nature still has rights within legislation. Can you help us to understand how are those concepts distinct or additive? And importantly, if we work on rights of nature legislation and passing those, like Yaffa has mentioned in Santa Monica or in Ecuador, when nature is harmed, what do those additional legal rights provide? What else are we gaining? Where else do we need to go?
Mhm. Well, for instance, if within an ancestral domain, because we do have a lot of indigenous peoples, and these are sacred grounds, they have lived there for centuries, they get their non-timber forest products there, and then there's a threat that the area will be mined, okay? The important consideration there is, will they be able to recover, to restore that important sacred ground, a ground which is, very rich in biodiversity, not only for themselves, but for the future. Because we have to make sure that the future can survive. The survival of nature is also human survival. So in a sense, if you protect, let's say, the habitat of the pangolins or the whale sharks or the dolphins or the forests, and a lot of the unique biodiverse areas, it eventually will have an important, significant effect on the people themselves. Because we know that, especially with the climate crisis and in the Philippines, the impact on the climate crisis is also has a peace and order impact. In fact, even conflicts can be the consequences of this problem. So it is important to look into how human beings actually relate with nature. And for me, that would be a value added. If our laws actually would be strengthened to make sure that the remedies, not only fines or imprisonment, but really remedies to restore them to the original state that's provided for by law. Our rules of procedure for environmental cases can actually provide for those remedies. But to me, it's very important that people understand, and the enforcers and the implementers also understand what this means and what are the consequences. Otherwise, the additional value, Jacob, could not be achieved as an outcome.
Philippe, can I throw that question over to you? Yes, please.
So maybe actually it's a perfect contextualization of maybe the same points that we're going to make differently. I guess one of the additional value, maybe the recognition of the intrinsic value of nature, which allows us to go away from that commodification trend that's been the hallmark of the last few decades, an economization or commodification where everything needs to be seen through the dollar value that nature is supposed to reflect, a lot of which we are dealing with right now. So in that sense, rights of nature is not only additional, but also distinct, I guess. Another one would be, and that's what was just mentioned in a way, is considering nature for itself, where that's not the case. So as opposed to looking at nature in terms of remedies which link or which are considered in terms of the human remedies, look at it through the perspective of nature. One of the ways in which I thought it's easy to compare the two is what we've had with the discourses on human rights, where in many cases, before the right to environment was enshrined in lots of different constitutions or treaties, where the environment was taken into account or given a place within the context of rights that had nothing to do with the environment, which has proved, typically in the European Convention on Human Rights, to be an amazing starting point that has allowed for lots of things to happen. But it's still not the same that we've known for years. It's still not the same as having a right to environment per se. So here we have something similar. And then thirdly, there is also the potential to rethink existing mechanisms, civil liability, so for private sector actors, state responsibility, which could be through a new way of understanding the harm. So let's say care for nature per se, in terms of, let's say, addressing the mass extinction, or in terms of climate crisis per se, but not in terms of looking at, or not in terms of the starting point we have for the time being, which is to look at it through the impact that it's going to have on economic growth or development generally, but looking at it through a different and or additional lens.
Thanks, Philippe. Then to follow up on that, so this is more expansive, potentially in terms of kind of legal avenues, but also in terms of ways of thinking about human nature environments. You were referring to not just the economistic framing, but also respecting and appreciating and remedying these intrinsic values that nature has. And yet, when rights of nature is reflected, at least to the general public, we often hear things like, okay, this is the right of a river to have legal body, to go to court. But of course, a river, an orangutan, does not go to court. So a key question that I am still trying to understand is, what does it mean to give nature rights when it's me or you or a state agency that still has to go to court to speak for it, right? Because it cannot speak for itself in our human fora. So when nature is harmed and nature has rights, who speaks for it? How does that work?
Well, that is one of the criticisms of the rights discourse per se, because it is, after all, very anthropocentric. And as of now, for the time being, to be able to give a voice to nature, there is a human intermediary somewhere that comes. There is a human voice in the process somewhere. So in court, in a way, it's a process which is well known, that there can be an advocate who speaks on behalf of someone else without having a direct interest in the matter. So it's a way, it's a mechanism which is known, but the problem remains always that if the central entry point is ecocentric versus anthropocentric, then it's still a human being trying to speak on behalf of something or someone it does not necessarily understand fully. But that's where the ideas that has been thought through in terms of, for instance, future generations representation has been debated for quite a long time by now, and that's already been implemented in different contexts. I guess maybe to give some further examples in terms of the different types of legislation or legal instruments we've had. For the time being, the mechanisms we have are human-centric in a way. They start from being fully human, as in the case of the Wanganui River in New Zealand, where the mechanism is not so much trying to give a voice to nature per se, but to do that by restricting the power of the existing powers over nature, that is, in this case, the state, and giving more power or rebalance to actors that have been understood, that are known, that have their own rules and practices, that are better at ensuring the sustainability of the protection of nature. So it's more rebalancing of different human lenses onto the environment that we see here. Another way that has been proposed in different places is to say that every person in the country could act as the voice of nature. In certain contexts, it can be a mix of state actors, environmentally minded civil society actors, riparian communities or people. That's, for instance, what was proposed in the case concerning the protection, the legal personality of the Ganga and the Yamuna in India. One of the ways to address various shortcomings that these different perspectives have been seen to have in terms of the ecocentric perspective is to move towards institutions or bodies that are more directly ecocentric, or at least that are framed specifically in an ecocentric manner. One of the ones that has been mentioned as having some potential, but it's a way to reframe what we have. It's a mechanism we know, so it's easier and take it forward. But that also, if it's known, that also means that it's again at the outset anthropocentric, is the public trust doctrine. The reason why it may make sense somewhere is because public trust doctrine had nothing much to do with the environment until the 1980s, where progressively it was opened up, it was given a new lease of life in a way and reframed in an environmentally minded way, because that's in common law countries mostly. So in that sense, there could be another rethinking or reframing of the public trust or public trustee as an ecocentric trustee. But if that was the case, then there are specific elements that need to be brought in terms of the discourses that have been had around rights of nature. And again, for the sake of brevity, one of these elements is the understanding that the top-down nature of environmental law over the past 50, 60 years has been one of the reasons for the failure of achieving the measures of enforcing, implementing, and achieving the results that have been sought, and that there is an absolute need to start from the ground up, which is what the focus on indigenous peoples and riparian communities is in a way meant to indicate. But so even if you were to reuse the same mechanism as the public trust in a different framing, it would have to be in a different light and through a different entry point.
Philippe, I think that last point for me is really resounds, because I know that, of course, the focus is on marginalized communities and empowering them to speak up for their own rights and to be representatives, trustees of nature's rights as well. But also, even for me, my expectation is that nature's rights, that they would be upheld by some anonymous state. And part of my interest in this as a scientist, as a conservationist, has been recognizing that actually the law says in many jurisdictions that responsibility and that right is far more distributed in many jurisdictions than I ever expected as a non-lawyer. And I'm curious, Gerthie, in a context like the Philippines, with or without rights of nature per se, who can stand up for nature's rights in the context like the Philippines?
We have a citizen suit in the rules of procedure for environmental cases. We have a provision for a citizen suit. So it's not only directly aggrieved communities who can file cases, but even non-government organizations have also standing. So we have had cases where a group of fishers and 2 lawyers represented the marine mammals in Tanyan Strait, and they were considered stewards of the marine mammals. The protected area was a subject of oil exploration, and the High Court actually said that it was null and void, did not go through the process, and it was a protected area. I think also other issues like the cleanup of Manila Bay, while it did not specifically identify the natural resources there, but it compelled government agencies to clean it up because it's for the people. Again, it may be anthropocentric because it's for the fishers, but there is recognition that it has been a source of fish and also marine biodiversity. Yaffa mentioned public trust, Jacob. I also like to highlight that we have a case where even if it's a government entity who violated the law, who breached the law, the Supreme Court said that given that water is an important resource, and they applied the public trust doctrine that it does not only apply to private citizens, but also to government. So it's a range of actors, even government agencies, local government units can also initiate actions in the country. And this is good. Of course, it's a tedious process to do that, but it's a good start to protect and push for the rights of nature.
Thank you, Gerthie. I have an unfair question for Maribel. We're hearing from our colleagues that in existing legislation, nature has loads of rights. We know this from the work that you and I have collaborated on. We're hearing from Yaffa and Philippe that rights of nature, expands these opportunities and reframes them in certain contexts, potentially expands standing of who can bring forward legal action potentially. So we've got all these rights. What's the problem? What are we waiting for?
I think and I'm going to reply from our experience, of course. the laws that we've seen are complicated. Every time that we search in a country for these rights, we have to look into many different pieces of legislation. Some of the time, sometimes the laws are old, and these combined with laws that are newer. So it takes, even for a lawyer who has an interest, even for a local lawyer, and I think Gerthie and Blair can share this opinion with me, it takes time to understand that the laws are there. It's important to communicate, because even when the laws are there and we analyze them, when you talk to the legal community, legal stakeholders, the public prosecutors, lawyers, NGOs, they don't know that this is there. So it requires communication, it requires getting together and discuss. And then once we've done our job as legal researchers of bringing to light what's in there, of course, this needs to be put into practice. And then we start looking at, the difficulties that this implies in terms of procedural obligations, in terms of bringing something to court, delays in the process. But, well, just to leave with the positive thought, so far in all the countries that we have looked into, these rights exist. In a bigger or in a smaller way, these rights exist, and they have been put into practice in some countries.
Thanks, Maribel. I promised you that unfair question, that broad question. I'd like to also ask Blair if you might share some insights with us. Uganda has both rights of nature and has loads of other legislation. What are you seeing? What are the barriers to operationalizing nature's rights when it's harmed?
Thank you very much, Jacob. I would want first of all say that in Uganda, the law is actually very, very broad in terms of giving rights to either citizens, to either government bodies, or even NGOs, or any person who feels that nature has been harmed. They give you a right to commence an action against any person who has caused harm or who is threatening to cause harm to the environment. And interestingly, the law is very clear that you do not have to prove even any personal injury or personal harm for you to be able to bring an action to enforce nature rights. So the law is there, it is very broad, but like Maribel says, there are many challenges that perhaps always stop us from enforcing the rights the way we should have. First of all, the nature of our, I would say, the nature of our processes are quite very technical. And we find for you to be able to prove that harm has been, caused, you want to either attach some value to the harm, you want to quantify the harm so that you can ask for compensation. Sometimes the technical capacity to actually gather this evidence is always not available. And you end up resorting to easy ways of perhaps remedying the harm, like preferring a criminal charge or looking for some restoration orders, which in a way do not actually address the harm to nature as it was caused. So there are some of those challenges that always affect bring the actions in terms of nature rights. Also, the knowledge. Most people do not seem to appreciate environmental rights, nature rights. Yes, the law is there, but the understanding is not there. So there is need for a lot of capacity building in terms of looking at how to build the capacity of, let's say, lawyers or prosecutors or investigators or judicial officers themselves who are handling these cases, so that they can understand really the nitty-gritties of how these nature rights are supposed to be enforced and what remedies apply to different cases, so that when someone brings an action in court, it can be attended to very adequately and very, I would say, professionally. There are many challenges that in most cases really discourage many people from taking up actions in relation to nature rights. But the law is there, it's sufficient, it's broad, And it will be very useful for anyone to bring an action to courts in terms of mega rights.
Right on the whistle. Thank you, Blair. I mean, I think that that's both really exciting and perhaps also really unsurprising, which is that where there's an easy known approach and a much more challenging one that requires us to think about intrinsic values and different types of legal strategies and standing and rights. It's perhaps unsurprising that most of our mainstream legal processes have opted for the more familiar, simpler solution. Yaffa, I'm going to ask you to give very briefly, because I know that you have written really extensively about the challenges of rights of nature. Can you give us a minute or two on what do we need to do? What do we need to do to see these rights operationalized when nature's harmed?
I think we need to talk about rights in litigation, and that gives courts the opportunity to develop the law, the laws that exist and the laws that are not yet explicit about rights for nature.
Thanks. I mean, one of the things that has surprised me in my work is that both for conservationists, we expect that there's lawyers that are going to know the answers to how we do this. And so we come knocking on your doors. And I think a lot of lawyers have a lot of questions for us, like what is harm? What are remedies from a scientific perspective? And so I think you're absolutely right, which is greater communication and understanding these rights, talking about rights and across disciplines is key. Sorry, go ahead.
Now I see what you're getting at. Yeah, we need to also, of course, we need to work with lawyers and scientists need to talk about what nature needs from us, because the law is typically not written from a scientific perspective, and in many cases where rights of nature laws have failed, it's because they're written in a way that's so vague, can't really be applied by courts. And using if more science went in the beginning, it would probably there'd be less legal uncertainty, and then the courts would be more comfortable applying them.
I mean, I guess it's in the name, isn't it, right? Rights of nature. It's not surprising that we need people who understand rights, people who understand nature to be having these sorts of conversations. I would like to turn over briefly. Please, if you've got any questions, throw them into the chat, any comments, and we'll follow up. But I would like our colleague, Rika in Japan, who has been keeping track of the chat, to perhaps ask a question or two from the audience. And if you've got any others, we will follow up, if not now, then via email. So over to you, Rika.
Right. Thank you, Jacob. There are a few questions. We will try to address all of them, but if not, then we will follow up through email. The first question is actually related to your last conversation with Yaffa. Is there any standard way to define and quantifying harm? This is a very basic question, but then it has been discussed in many forums because it will determine how the liability is triggered.
Who shall we attack that question with, Rika?
Well, I will say first we could ask for people who are familiar with the law, who has been in the court and probably has experience in defining harm in the litigation. So
Gerthie, Blair, I think that's you.
Yes.
Okay. Yeah. Can I respond initially? Because when you establish harm, you talk about you quantify. You quantify the harm, and in our jurisdiction, you do have what is known as damages in the civil code. Okay. Of course, there's criminal law, but I think that the challenge is really giving value to the ecosystems, goods, and services, because you can value, example, minerals, but what sufficient value do you give to the forest? Because it is not just simply trees. You do have wildlife there, the value of the soil, and all other values, carbon, air, etc. So you should go beyond what we have by getting science, getting scientists and technical people and even resource economists to be able to establish that harm if we want to fight for rights of nature. Because I'm I'm talking this way because you do not have a specific law yet, but taking on the Wildlife Act, Protected Areas Law, Fisheries Code, the way we do it is we definitely quantify and give value so that when we say that this has been destroyed by an illegal fish pond or by an oil spill or by extractive activity, then you have to indicate that by way of testimony, of course, and other documentary evidence. Object evidence, of course, will come into play. And therefore, there are technicalities involved. It is not easy. It's not easy to do that because the evidence basically falls on us. However, we do have a precautionary principle. I'd like to say this in a rules of procedure that the lack of absolute scientific certainty should not be a reason for inaction. So, as an example, there is a case, the genetically modified organisms, the Bacillus thuringiensis, where it was applied, that if the scientists they were able to establish that the harm is irreversible, it's serious, among the elements, then the principle will be applied, and therefore protection should actually be ensured rather than allowing a destructive project to proceed, just like the GMO type of a project. So I hope it makes sense. It's still a work in progress, I'd like to believe. And therefore, we need to pool our resources together. I think the scientists, not only lawyers, we need more environmental lawyers, and we need to make government also understand this, understand what it takes to establish the risks, the harm that can ensue if you do not protect the biodiversity, our wildlife, our lands and coastal resources. Thank you.
Thank you, Gerthie. I just want to say I'm conscious of the time. Colleagues, I know that if many of you will have other meetings to run to, so please feel free. We're going to go on just for a few more minutes, and of course, we'll make the recording available at the end. If you've got any questions, please throw them in the chat. Let's throw that same question over to Maribel, please.
Thank you, Jacob. For me, the short answer for this question is no, there is no standard way of quantifying harm. But I would like to throw the question back to the audience and ask, should there be? As I said, we tend to think that when there's harm, there's a sort of an economic loss. And there are some countries that have a list of let's say, of economic value for animals. There, for instance, the country of Georgia has a list of how much animals are. So a brown bear equals to 40,000 euros. Now, does a brown bear care that he's worth 40,000 euro? Does this, when we get the 40,000 euro, are we remedying the harm that has been caused to the bear? So I think it's important, as Gerthie was saying, not to mistake value for economic, monetary harm. And some laws across the world reflect this very easily. I think in our perspective, what we should be looking at is into list of things that are needed to repair a specific harm. And once we have those list of things, then we can start putting prices. There are also other values, specific, very important values like cultural values, religious values. How are you going to put a price on that? So it's a difficult question, but a question that we need to ask ourselves, absolutely.
Thanks, Maribel. I just want to, there's an expression, right, that you shared with me a long time ago. Solo el necio confunde el valor con el precio. Only the fool confuses price with value. Rika, what other sorts of questions have popped up?
The next interesting question is how we can advance the role of indigenous people. As some audience also point out, the right of nature are most likely be welcome in a country where indigenous people reside because of the aligned value on it. And that I think it's interesting if we can get a response from Philippe and Yaffa as well in this. And it's also related to the other discussion on who actually can enforce this right of nature. Is it also part of the way we encourage the role of indigenous people in this area. So please, Philippe and Yaffa.
Yaffa,
Should I start?
Yes.
Okay. Yeah, thanks. I think that many of the rights of nature recognitions and cases that have been the most powerful are ones that also acknowledge the people who are part of the protected ecosystem or have a relationship with a protected ecosystem. That has included Indigenous people, famously in the New Zealand recognitions for nature. It also has included communities who live by the water body. For instance, in Spain, the rights of Mar Menor, also recognize the needs of the people who live by Mar Menor, though they're not considered indigenous people, but they are people who are most dependent on the water. So I think, yeah, in different types of cases, and also I want to mention the Colombian Atrato River case, which involved the rights of an ethnic community who was harmed by pollution to the river. They had not asserted rights of nature, but the court held that the Atrato River, that they had to declare the rights of the Atrato River and the Atrato River as a legal person, in order to protect the rights of the people who interacted with the river. So I do think that it's very powerful. Also, we see it in when it comes to non-Indigenous people in a case that followed that case, where the Supreme Court of Colombia declared the Colombian Amazon to be a legal person. They did so because of the human rights of people living in cities, of young people living in cities, and said nature has, intrinsic value because people are part of nature and people have intrinsic value. And so it really connected these. And I think that's true both in situations where there's particular indigenous communities or other types of communities. Although, sorry, no, I'm going on. But some of these rights of nature, like the New Zealand cases, recognize the kinship that the local iwi had with nature. There's a statement, I'm the river and the river is me. But likewise, I believe, that I'm mostly water. I believe if I don't have access to water, I will die in about 3 days. And I believe that these are not unusual in Europe, beliefs in Europe. So I think that, yeah, that there's potential for rights of nature in many types of legal systems.
Okay, maybe just to add an additional lens, I guess one of the reasons why there's been a lot of focus on indigenous peoples is because in various countries, that's where there has been an understanding that something different has been happening from the formal environmental law based on the same principles that we find in most countries, as in that the diffusion from the international to the national level that's happened with international environmental law. So that idea that there are different things happening. But clearly, if right of nature is going to be something which spreads, which can have traction beyond this specific context, one is it will not work to oppose what is essentially an urban versus rural context, because there is that image of indigenous peoples living in natural context, but most of the pollution that arises, whether it's let's say the river is the easiest one, most of the pollution of the river will be due to the urban areas along the course of that river. And there is the other thing which is now reflected in, for instance, the Marmenor case, as well as all the other initiatives that we're seeing in the global north, in a way, is that if we say indigenous people, that's been one of the reasons why some countries in the global north have been relatively cold on that idea of rights of nature. Not the only reason. But clearly there is all that we've already moved beyond that. So it's more about recognizing the need for people living in close connection, whatever kind of connection that may be with a certain environment, to be able to have a direct say. And that is where we go back probably to a more decentralized implementation and potentially enforcement of the norms, rather than through these top-down institutions, which often end up being subjected to all sorts of forms of diversion. Okay, there may be the direct corruption, but there may be lots of other things happening as well.
Thank you, Yaffa and Philippe. And the last question we will discuss is, this is an interesting question, how to provide a timely remedy for harm to nature. This one the audience point out, because there is always a lag between legal action and rate of destruction that happen. So is there any kind of innovative strategy to deliver a timely remedy, restorative remedies for harm to nature? That will be the last question. And I think we can start from Gerthie.
Yeah, actually, there's no hard and fast rule, I would like to say. From my experience, we combine it with legal and what we call meta-legal remedies, like campaigns, because I wanted to share a while ago that governance is equally a challenge. It's part of the problem if the government agencies concerned do not implement the law. So how do you expedite that process when we do have a lot of obstacles? So you definitely will want to work with communities, still engage with the government, combine it with litigation, but the never-ending effort of campaigning, storytelling, advocacy work, and organizing. These are things we need. We call it meta-legal, even people's actions, combining it with litigation. So even engaging with government is a constant struggle and a challenge. So to me, you cannot say that you can achieve it immediately, but I think patience and perseverance will definitely be needed if we want to strengthen vigilance in this country and all over the world. Thank you.
Thank you, Gerthie and Maribel. Since you've been looking at this in various countries, is there any strategy to expedite restorative remedies? Because we don't have much time, apparently.
Yeah, and I what Gerthie has said. Really, she's replied the question very well.
Okay, one last statement from Blair. Is there any strategy you would like to share?
Thank you very much. I would first of all want to agree with what Gerthie has said. Working with government, usually government bodies, at least for us here in Uganda, have statutory powers that can help go through the lengthy litigation processes that will give you a solution at the end of it all.
Okay, thank you, Blair. I will give it back to Jacob to conclude the session. We will follow up via email for the rest of the question.
Yeah, that's right. Thank you, Rika. And we'll share these questions with our colleagues, and we'll ask everyone to give their feedback, and then we'll email those back out. One of the things that strikes me is that both as an environmentalist, as a conservationist, as an academic, as well as someone who's been collaborating with lawyers for a long time, is that there are a lot of environmental rights, both existing and rapidly changing. And rapidly changing sometimes very clearly and well-defined. But the norm seems to be, whether it's old legislation or new legislation, as Yaffa was mentioning, there's a lot of questions. There's a lot of things that are being asked of plaintiffs who are bringing cases to innovate, a lot of things that are being asked of prosecutors to sift through, and a lot of things certainly of judges who are often not environmental experts to try and determine. And that's a big ask. I mean, we in this room who are experts and enthusiasts of this topic, I think really struggle, and we've barely begun to scratch the surface today. So on one hand, the challenge is pretty considerable. It's a confusing topic. But on the other hand, the rights are there, the rights are emerging, and the request is clear, which is of access to justice for nature and for human communities, and for all of the areas in which those are intertwined. Now, we don't have any easy solutions or single legal pathways, but what we do have are potential solution and potential legal pathways, many of which have yet to be meaningfully operationalized. So I really thank our colleagues today, practitioners and scholars alike, for helping us start to sift through these things. If you would like more information, please be sure to sign up in the chat. I hope this is the first of many conversations with conservation litigation, with the IUCN Task Force on Rights of Nature, with the Biodiversity Law Specialist Group under the World Commission of Environmental Law, and indeed, importantly, and I will say lawyers, but also non-lawyers alike, as we start to work more towards operationalizing these rights, talking about them, thinking about them, but also using them. So thank you very much, everyone, for joining, and I look forward to seeing you in court. Take care.